Hello, hello, hello. This is Attorney Mark Grevlin coming to you from Chicago as usual. And Zach over at Law Nerds Unite has hooked us up with something special. We've got the most Karenist Karen that ever did Karen. I'm calling her Dirty Sanchez. You'll see why. I got some other clips from Zach and also MGT, and apparently MGT sent me the soft set that I just did in the last stream. Big shout out to MGT. Let's get this party started, shall we?
In person today. Miss Sanchez didn't want to do it today, so it needs to be pushed out to a different date so she can be in person. Let's go ahead and look at the dates. So the next availability is November 19th at 3 p.m. Does that work for all parties?
We'll make it work here.
With what, Judge?
What do you mean with what?
With what judge would be there? Is it you?
I am the judge, yes.
Okay, well, I'm going to put in a request for a different judge because I would like a fair trial, and I don't think you're being very fair with me.
That's wonderful. Please file the paperwork. That
I definitely will.
Sounds great. All right. So the hearing, 3 p.m., courtroom 6. Does that work for all parties?
Yes.
Yes.
Okay. All right, let's get that in the system. Okay, so now that it is moved to November 19th, 3 p.m., courtroom 6, you have the opportunity to appear in person or virtually, okay? So if you do not want to be there in person, you do not have to. It's the same login information. It would just be in courtroom 6 and not 8, okay? So that would be at 3 p.m. And let me look up the dates and give you the new drop-off date. So Rodman Realty, we do have all your exhibits that have been submitted. So you do not need to resubmit your exhibits. If you want to additionally add anything in, you may, but these will be reserved for the trial on the 19th, November 19th, okay?
Okay.
If any party wants to additionally submit any exhibits, you will have until the 7th, November 7th, which is a Friday. There needs to be 2 copies of every exhibit submitted, so that way the court can retain a copy, and that way the other party can have another copy of the exhibit as well and just know what is being presented against them. So let me go ahead and open this. All right. So I believe you already, Rodman Realty, you guys already presented 2 copies of everything, right? So you don't need to double up. Okay. Nothing was received from the plaintiff at this time.
Rodman has.
I have no idea what this controversy is about, but I'm saying right now, judgment in favor of Rodman Realty.
You have until November 7th to submit any evidence that you would like to submit. It needs to be 2 copies of everything. So that way Rodman Realty can come and pick up anything they may need.
Rodman has received exhibits online. I'm not going to argue with you. You're being extremely disrespectful yourself. And I have rights as a citizen and in a courtroom.
I'm really sorry. I removed her into the waiting room for her to cool down for a second.
Okay.
I'll bring her back in a few minutes.
Okay. But you see what we've been dealing with.
I'm not going to make a comment on that, but you don't get to talk to people like that, especially to a judicial officer. So I'm going to give her a second to calm down.
Okay.
So yes,
Mm.
I am witnessing a lot. So, but I'm not going to make a comment on it, but yes.
Of course. Right.
You sure are. Oh, this is just top notch. I've been trying to stay out of the way of it, but the facial expressions, everything, I could watch it 10 times. Meanwhile, I've had this judge on before. She's a sweetheart. She is one of the nicest judges out there. She's excellent. She's a good judge, and she's very nice.
It is disrespectful. Mm-hmm. So I apologize. We're just going to wait a few minutes, and then I'll bring her back in. And if it keeps happening, she'll just receive notice in the mail with the new court dates, and I'm not going to tolerate this. So, Madam Clerk, we're just going to stay on the record. We're just going to, it's November 7th. Yes, November 7th was the additional evidence day, and then November 19th at 3 p.m. courtroom 6. Yes. Okay, so. Okay, so let me look up this court rule for affidavitting a judge, because she may be very happy with what she's about to find out.
She comes back.
Get this. Okay.
All right, Madam Clerk. So, Madam Clerk, we are going to bring her back in. If at any point she starts being rude, can you just mute her and she can just listen? Yes. Okay. All right, so we are continuing on with this setting of date.
Oh, there's our delicate flower. She's back. And I'm sure she's adjusted her attitude. I'm sure it's all going to be awesome.
Dates. So November 7th will be the date that all parties can turn in 2 copies of every exhibit. And then November 10th is when all parties.
Oh, she's muted. She's muted. You know, I do have one question for her. You guys will never believe it, but I do have a question prepared for her.
Ma'am, are you a whore?
Can come and pick up any exhibits that may have been dropped off for them. As I said, Rodman Realty, we already have your exhibits. So if there's anything in addition that you want to drop off, it would be the 7th. You do not need to provide copies of the previous exhibits again. That is already for pickup for Miss Sanchez if she does want it. So just clarifying that. Okay. All right. So November 7th. Okay. Well, there we go. So I mean, I guess she could have signed off. There was nothing additional that needed to be said. So 7th, 10th is pickup, 19th is trial. I think she's going to be very unhappy when she finds out that I will be the judge there, but there is a chance that she can try to affidavit me. I think she has passed the deadline. So I'll probably see you on the 19th.
Okay.
Okay.
We look forward to it.
Yes. Very, very excited for it. See you on the 19th.
Okay. Have a great day.
All right. Thank you.
Thank-
Bye.
I have to thank Zach again. That was absolutely fantastic. That's one of my favorite clips I've seen recently. It was short, but it was quality through and through. The facial expressions, again, I've seen it a couple times now. It gets better on second viewings. It really does. Oh, it's good times.
All
See
parties.
you. We can leave now. How do we do that? How do we leave?
I think you can just exit out right there, right? No. It should be something that says like playing video.
Miss Pratt, come up, please.
Yes. If that thing goes to hearing, somebody tell me. I want to see all court appearances involving Dirty Sanchez. Let it be known right now. This is fun too.
Miss Pratt, why won't you give me your analysis this morning?
Well, that's the same thing we went through last time. That's why I have the patch, because I found out that I have a tumor in my kidney
Okay,
while I was in jail, so that's why I can't urinate.
okay. Because I have notification,
The lady came from Vienna to put the patch on. It was real late at night in jail.
So I have notification dated yesterday, the 6th, that you got a drug patch on August 31st when you were in the jail, and that they haven't seen you back to change or put another patch on you.
2 weeks ago, they didn't tell me to come back to check. They didn't give me a date or anything.
I don't believe
I
that.
thought I was coming today to get it taken off when I came, or yesterday.
That's not what I don't have, that's not true. So I'm going to
I had
find,
the paper at home. I didn't bring it with me.
well, you didn't show
Judge West is great too. She was trying to be gentle about it. She just retreated to that's not true.
yesterday, you didn't bring what you needed today, you haven't got your drug patch changed, you won't go to the restroom.
Well, she said 2 weeks.
Right.
You changed it.
Yeah,
Yeah, so it's been that right now. I was going over there when I left court. I was here yesterday. I was in the parking lot.
you being in the parking lot doesn't do any good because I'm not in the parking lot, am I?
Right?
Okay.
Yes.
Your criminal history is prior felony possession of controlled substance cases. The fact that I have notification that you have not changed the patch like you're supposed to, and that you, in my opinion, appear to be potentially under the influence of something this morning. For the record, it looked like you were sleeping, having trouble staying in your
I've
chair.
been up all night crying.
Okay, I'm going to raise your bond this time for violating your condition of your bond that you have a drug patch and have it changed every 2 weeks in the appropriate way. I'm going to raise your bond to $20,000. Condition of that bond obviously is that you have a drug patch. You got to figure out how to do it. You have to figure out, ask the questions, get it changed the right way at the right time, and then we'll see what happens from there. You can go back with the bailiff.
Yep, I don't believe you, and I think you're on drugs. Bye-bye.
For 25 CRB 1131 and 25 CRB 1260, State of Ohio versus Dale Dotson.
Big in.
Mr. Dotson, today's hearing is being recorded. Anything you say can be used against you in the future. You have a right to an attorney. If you cannot afford one, you can make an application for a court-appointing attorney. I have 2 complaints here charging you with violating protection order. Did you receive a copy of those?
Yes, sir.
Okay. Do you need me to read those to you?
No.
Maximum penalty is 180 days in jail and a $1,000 fine. Any question about the charges?
No, sir.
How'd you like to plead it in?
Not guilty.
Want to say anything before I set your bond?
Yeah, right now I'm coaching Little League football, and working. I asked for a lower bond. I got court coming up on the 18th down, 16th and 18th down here. I mean, I've been attending my court dates. It's supposed to be over with here, so kind of shocked here. Other than that, nothing else to say this time.
Ms. Yeager, you have a bond recommendation?
Yes, Your Honor. In regards to Mr. Dotson's other cases, those are all set in front of Judge Stansberry. It's 24 CRB 327, 417, that may be backwards, and 1744. Those are all consolidated and set for jury trial on the 30th. He is represented by Mr. Barstow in those matters. The 18th, by the way, is a Saturday, but his next court date was for a bond revocation set for the 13th, the next Monday. In these 2 matters, he's in 1131, he's accused of contacting a protected party on the protection order who is also a victim in 24 CRB 327. And then in the other new case, the person who he's accused of contacting is a sibling to that victim. And both of those individuals are the younger siblings to the other victim in the other cases, Courtney, who has been in here and addressed this court before. She did actually send me an email she would like Your Honor to read on behalf of her siblings. Your Honor, these matters with Mr. Dotson contacting this family as protected parties has been going on since the beginning of 2024. Every time we get close to a jury trial date, things amp up and we end up with new issues of some sort, whether he failed to appear, whether he committed a new potential violation, and so on and so forth. And I know I put some of the bond recommendations on the orange sheets, but at this point, Your Honor, I'm kind of at a loss. He just will not leave these people alone. So
Allegedly, sorry, but it's allegedly. I haven't had any contact with them.
the middle of my sentence didn't interrupt the beginning of yours. Please let me finish. So these allegations resulted in new charges, along with several motions to revoke bond. And at the end of the day, he needs to leave this family alone. So we would ask for a high cash surety bond, as we have been here doing this dance for almost 2 years, trying to resolve these matters and really just, again, trying to get him to leave this family alone, in which he seems impossible to do, between contacting with over the phone, social media, so on and so forth. It's at a point, it's just ridiculous.
Behavior in this case is disgusting.
You're welcome. Okay, set your bond at 10,000 cash surety on each case, with the condition that you abide by civil protection order. Any question about that?
Yes, Your Honor.
Yeah.
Is it 10%?
No.
Can it be 10? It's a misdemeanor. It's non-violent. I mean, I've already been pled or convicted or found not guilty on one of these charges. This is absolutely insane. I mean, she wants to use these other cases, yet I've been found not guilty on them.
Good. Thank you. Next matter is 25 CRB 1290, State of Harbor, Moor, Houston.
That would be a no.
Robert Paredes, that's a sentencing, 3 cases. All right, you are Robert Isaiah Paredes.
Yes, ma'am.
And Mr. Paredes is on probation in cause numbers 16-24053, that one for prohibited weapon possession, 20-35328 for aggravated assault causing serious bodily injury, and 20-35329, also aggravated assault causing serious bodily injury. Was in court previously entered pleas of true to counts 1, 2, 3, and 6. I've received an updated pre-sentence report. Have you both had an opportunity to review that report?
Yes, Your Honor. Yes, Judge.
Any additions or corrections?
Nothing with that.
Any testimony with regard to any of the other allegations? Mr. Smith?
Judge, we have a person here for...
I'm sorry, I can't hear you.
We had the probation officer here, if you'd like to hear from him. I believe that, yes, I did address...
I mean, I have what he put in here, but I just am asking if there's any witness, if you want to put in on any testimony for the counts that were not pled true to or not.
I would ask him a few questions if the state's not going to call him.
I guess we will do.
All right, Mr. Patton, if you'll please raise your right hand. Do you swear or affirm the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
I do.
Thank you, sir. Go ahead.
Mr. Paredes was ordered to perform community service, and has he completed all of that and provided verification to the probation department?
He is not, no.
And did he appear for alcohol or drug screening on June 18th, June 25th, July 2nd, July 5th, July 21st, 2025?
What were those dates again?
June 18th, June 25th, July 2nd, July 5th, July 21st, 2025.
So June the 18th, he did not show. June the 25th, he did not show. July 5th, he did not show. Then July 21st, he did not show.
That's what it's.
I guess I want to know with regard to community service, obviously what has he done out of any of it, if any?
Your Honor, in cause number 16-24053, he has completed 169 hours out of the originally assessed 300,
Okay.
which leaves him with 131. He last performed community service on April 4th of this year. He worked with our work crew at my Beaumont office. He has not performed any of the community service in either of the other two cause numbers.
Okay, thank you. Mr. Kimler?
Shouldn't the community service be concurrent in all three of the cases? In other words, the community service that he's done in one case should transfer and be credited against community service required in the other cases?
It is, yes, sir, correct.
So he would have 169 hours in each of the three cases?
Yes.
Correct? Is that right?
Yes.
And is that so even though he was already on probation on one and then we gave him probation on two after that?
It is typically how we do that, Your Honor. We typically will give them credit for community supervision on any of the cases they're doing for us, regardless of when they started supervision.
Community service?
Yes.
Yeah.
Sorry.
May I proceed, John?
Yeah.
How long have you supervised him, Mr. Patton?
So I'm a supervisor at our department. I've seen Mr. Paredes on numerous occasions for administrative hearings, case staffings, and when I've held down a caseload when we've been in between officers.
Because you have some familiarity with him.
I do, yes, sir.
And during the times that you supervised him directly, has he maintained proper demeanor with him?
Yes, sir. Yes.
Proper decorum, all those things?
That is correct, yes, sir.
And should he continue on probation, you would not be the supervising officer, that would be someone else, is that right?
That is correct. I would not be supervising him.
Well, let's say, I suppose you acted as a supervising officer at some point in your career at the probation department, is that right?
That is correct, yes, sir.
Assuming, let's just speak hypothetically, if you were a supervising officer again, would there be anything about Mr. Paredes that would cause you concern to continue to supervise him as far as his demeanor and decorum and attitude towards the probation department or personnel?
Hypothetically, no, not concerning those items.
Who was his supervising officer?
His supervising officer was Alexandra Ariano. Ms. Ariano went out on maternity leave and elected to stay home with her child. And so we've since filled that vacancy with a new officer.
Okay. But she was the one that was, I guess, directly supervising?
That is correct, yes, sir.
You had access to her records, is that right?
I do, yes, sir.
Is there any indications in there about some type of mental health referral, anything of that nature?
No, sir, there's not. Not that I've come across.
And nothing in the records that indicate that there's ever been any type of mental health assessment or mental health recommendation for Mr. Paredes, particularly not for schizophrenia or anything like that, but perhaps depression or?
Not that I've come across, no, sir.
That's what it is. No further questions.
All right. So, Mr. Paredes, it shows here in this updated pre-sentence report that one of the things you told Mr. Patton was that you'd been on probation since you were 18 and you just couldn't do it anymore.
Yes, ma'am.
That's true. And then you said, I'll take a safe P. I feel like prison's going to make me worse and blah, 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 but I feel safe P is the best thing for you. So tell me what you're asking for and tell me why.
Well, at the time when I told him that I couldn't take probation anymore, that was one of the times where I was just feeling real down and depressed, you know, from everything that's going on in the past, you know, with me being shot and stuff like that. I was shot in my neck and my arm, so since then I've been having real bad PTSD, real bad depression, bipolarness. So, you know, there's some days where I'm good, some days I'm not, you know, some days I wake up on the wrong side of the bed from having nightmares, you know, and some days I'm just as happy as I can be. So from that point on, at this point, I know since...
Let me tell you how I don't care. But more to the point, let me tell you how Judge West doesn't care.
Being in jail now, this isn't what I want because it's just hurting my family, hurting my daughter, and being around the people that's around me, you know, being around murderers and rapists and, you know, aggravated robberies and all that, it's just a bad environment for me, and it puts me in a bad mood, puts me, you know, in a bad mindset, I guess you can say.
This court stuff is really inconvenient. You guys are harshing my mellow. If you could just go away, that'd be great.
And I did speak with the counselor I had that they assigned me for probation, and I did tell her those things, and they did recommend MH and Moor, but I never went just because I felt like it was I felt kind of low, you know, of thinking I would go to MH and Moor, you know, because
Stigmatized.
Yes, sir. So, at this point, I don't want to go to jail or to prison. Feel like being in here, sitting in here, has helped me realize that my life is on the line and it isn't a game and it isn't a joke. And but I do need help mentally. I was prescribed Zoloft the last time I was in here due to my PTSD, but I never took it. Because I heard really bad things about it. But now I'm starting to realize maybe I should be on Zoloft just to control the urge of smoking weed and you know, that kind of behavior.
I could ask him a few questions, Ron.
Sure.
I'm
I'm
sorry.
Best you can, raise your right hand. Do you swear from the testimony you're going to give in this hearing will be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Go ahead.
Explain those facial tattoos to the judge.
This tattoo right here is my daughter's birthday, 11/14/2017, and this is 9/16/22 is the day my cousin killed himself. He shot himself in the head. This was right after my uncle had passed of cancer, and my cousin who just passed away, his dad, my other uncle, had just passed due to cancer as well. That's why I turned myself in a week later after my warrant had came out. This tattoo on here is a heart and a music note. I got that for my ex-girlfriend, you know, just, you know, being dumb at the time.
No gang affiliation.
No gang affiliated tattoos on me.
And you did turn yourself in on the warrant?
Yes, sir. I did turn myself in.
How are you maintaining employment when you're out?
I always held a job. Even if it's working at Whataburger.
What was your last job?
Shipley's Donuts was my last job to maintain, because I got laid off. I was with Bechtel. I was a carpenter for Bechtel for about 1.5 years.
At the LNG plant?
Yes, sir.
LNG terminal?
Yes, sir.
What were you out? You were a carpenter?
Yes, sir.
Scaffold builder? What were you?
We were doing woodwork, building decks and carports and lunch tents and that nature.
And as far as being shot, that actually, I know the court, in looking at his criminal history, these are serious cases as far as the aggravated assault, serious bodily injury. You were actually shot during that interchange. Is that
Yes,
right,
sir.
by the other people?
Yes, sir.
And you would return fire?
Yes, sir.
That's not
I
what,
understand, Your Honor, but it's not, I don't want the court to think, I'm just looking at it, and I'm not trying
my
to.
understanding from the version in the pre-sentence report previously, and
I didn't represent him.
my recollection of it actually, because it's not good when I remember you. The fact that you were already on probation for a felony,
Right.
and then you came in and you admitted that you went there to shoot.
Ooh, this attorney was trying to slide this past Judge West, but he didn't realize that she remembers the prior hearings. Ouch.
You went there to go shoot Christy, which is your child's mother, right? That's not true? No? So did you mean to go shoot the two girls that got shot, Alexis and Taylor?
No,
Who'd you mean to shoot?
I didn't go there to shoot anybody.
I think as he explained it to me, he was going there to meet for sexual purposes, the two girls, and when he got there, he was set up in the parking lot, and then by other people.
That doesn't make it a lot better. It's not helping.
There about people who were going to rob him, and in the course of that, there was a gunfight. But he wasn't going there to shoot anybody.
All right, well,
He was going there for an illegal purpose.
That goes against everything that was said and everything that he agreed to back then, because
That's correct, Judge. We were getting ready for trial on this case.
Yes.
He was the aggressor. He was the one that fired first, and had he been a better shot, Alexis and or Taylor might have been killed, but he was there to go kill Christy.
I didn't represent him
Okay.
on that, so I don't know.
all right. Anything else? All right, Mr. Smith.
Okay, maybe he was.
I would agree with the probation that I believe he's only asking for safety now simply because it's the only alternative he sees to prison. I don't think he's sincere about it. We have given him chance after chance after chance, and he has squandered, wasted, and even though he's a nice guy when he shows up, he does what he wants to do. That's evidenced by the jail reports that shows that they tell him to go back to his bunk and he just gets in the shower with his jumper on. And then when they write him up about it, then he says, man, fuck you. He has zero respect for authority or doing what's right, what he's supposed to do. I think prison term is appropriate in this case. The PTSD excuse is weak. He was the aggressor in the initial contact. And you can't claim that, well, I feel bad because I got shot by somebody who was defending two other women. So I would ask for pen time in this case.
Anything else, Mr. Kimler?
Well, it's difficult for me to address always with these jail incident reports without having the opportunity to cross-examine the person that made the allegations. So I would ask the court to consider the fact that that's not subject to, those allegations aren't subject to the rigors of cross-examination. But I think that on Mr. Brady's behalf, struggling with depression is a serious matter, and I know, and I respect Mr. Smith's looking at this as a way somebody just volitionally or somebody just deciding to be stubborn and self-centered and not complying, but depression is a serious problem. He has struggled with that. I think that's indicated by the limited mental history that we have. There is no new offense allegations in this. These are administrative violations. Of course, those are important, especially reporting. But because of the seriousness of these cases, I would ask that the court give him at least one more chance with the aid of mental health, maybe safety, but also as a follow-up if he gets out to follow up with Spindletop to address not only any substance abuse problems, but any underlying mental health issues that may contribute to the substance abuse and just his ability to comply and just to continue on probation.
All right, thank you, Mr. Kimler. So, Mr. Paredes, the thing is, you've been given exactly what Mr. Kimler is asking for. You've already been given that. You said it yourself. They recommended Spindletop. They recommended medications. You made conscious decisions not to follow through with what they knew was best for you, which is part of your probation. Everything that they say you should do is a court order. the fact that you are on a probation from for possession of a prohibited weapon, like you said, from back when you were 18 years old, put you on a probation, 10-year deferred for that, November of 2016. Then we're back here, you're put on probation for 10 deferred on 2 aggravated assault causing serious bodily injuries in March of 2022 for shooting 2 girls. And you got shot in self-defense. And it appears that there's no real reason for me not to believe that that's how it happened for a number of reasons. No one else was charged with aggravated assault for shooting you. All the police reports, everything that went through in those pre-sentence reports previously that I have copies of, all makes it appear to be true that you went there to shoot either Christy and or whoever else. And luckily we're not a good shot. One of the girls got shot 3 times and survived it. And for you to say you have PTSD from getting shot, I can't imagine what she has. I feel like you've been given every opportunity. And when I look back on some of these times where I give chances like I gave you, it's very frustrating and a little embarrassing because it looks like I was not really thinking clearly then. I understand that these are drug allegations. You've been getting opportunities to get help. I mean, you've been on probation since 2016 with every opportunity possible. So at this time, in cause number 16-24053, I'm going to, also based on the evidence presented today, I am going to find count 5 true. So that makes you pled true to counts 1, 2, 3, and 6. I'm finding count 5 true based on that evidence in each of the cases. Find sufficient evidence in that case to find you guilty, and at this time find you guilty of possession of a prohibited weapon. Sentence you to a term of 7 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. In cause number 20-35329, also find counts 1, 2, 3, and 6 that you pled true to those freely and voluntarily. Find them true. Also find count 5 true. Find sufficient evidence to find you guilty, and at this time find you guilty of aggravated assault causing serious bodily injury. The institutional division of the Texas Department of Corrections. You will also receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. There will be an affirmative finding of a deadly weapon in that case. In cause number 20-35328, again, find that you pled true to counts 1, 2, 3, and 6 freely and voluntarily. Find those counts true. Make a finding of count 5 true. Find sufficient evidence to find you guilty, and at this time find you guilty of aggravated assault causing serious bodily injury. Sentence you to a term of 12 years in the institutional division of the Texas Department of Corrections. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. There will also be an affirmative finding of a deadly weapon in that case. All 3 of these will run concurrently, which means together at the same time. I am going to hand you a trial court certification. These were not agreements. You do have some rights to appeal. You can talk to Mr. Kimler about that. I need you both to sign and fill out the bottom, and you'll get a copy. I'm also handing you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgments entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term, and you should read the written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Kimler. All right. I'm sorry?
It was 7,
12 and 12.
12.
Affirmative finding of deadly weapon on both of the 2 cases.
There you have it. Judge West laying down the law, doing the right thing. It's beautiful. God bless her. She's a good one. She's a good one. I'm glad we have her. Seriously. Yep, that was from MGT there. For any of you guys who joined late, you really have to go to the beginning of the stream and see Dirty Sanchez. It's fantastic. It's fantastic, and it's not that long. Thank y'all for coming out. I appreciate it. I'll see you soon.